That's good enough. Can we start?
What time we got?
I have 7:02.
All right, yeah, give him a couple minutes. You know, your little speech takes a while, too. Doesn't show.
We're still okay, we have 3.
Right, can he participate if he doesn't, if he comes in the middle of it?
One in the box, sorry.
Oh, to vote.
I know those rules. The attorney's here, maybe she knows. Okay, since I have a long thing to read, I'll start.
Yeah, okay.
Good evening. Welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I'm Judy Freshman, Chairman of the Board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Inta Malice, Paul Melnick, and Peter Owen. Charles Smith will be joining us momentarily. Also present is the professional staff, including Deputy Zoning Administrator Andrew Noxon, who serves as Secretary to the Board of Zoning Appeals. Arlova Vaughn, Acting Zoning Administrator, and Clifton Hogan, Assistant to the Zoning Administrator, and Christine Sanders, Assistant County Attorney. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you have not seen the report for your case, that you get a copy and review it before your case is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. The board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1 and 2 family lots where there's no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint size and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the board must determine that the strict application of the ordinance would produce undue hardship, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and that the character of the district will not be changed by the granting of the variance. When deciding appeals of the zoning administrator, the board must determine if the administrator acted correctly. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of the staff they may have. Next, applicants or their representatives will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room, and give it to Mr. Hogan. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speaker, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for speakers to be sufficient. For an appeal, appellant 20 minutes, representative of organizations 3 minutes, and individuals 2 minutes. For use permits and variances, 5 minutes for applicants, 3 minutes for representatives of organizations, and 2 minutes for individuals. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Thank you very much and good evening. Our first case tonight is an appeal. Staff is going to give a brief presentation on the appeal, and then we also have with us the Assistant County Attorney, Christine Sanders, tonight, who will also aid with any questions that may arise from the board. The case is V-11142-16-APP-1. This is an appeal by Stewart Street Properties, LLC, and ML Smith Company, LLC, to a determination by the zoning administrator stating that two parts of Lot 81 may not be combined together as one building lot. It's in the R5 zoning district on a premises known as 1229 and 1233 North Stewart Street.
Any questions before we begin with the applicant? Okay, appellant. I have a speaker slip from Mark Freelander. Are you representing the appellant?
Yes.
Thank you.
May it please the board, I am Mark Friedlander, and I represent the applicant, or the appellant. And here's what the problem is. There were 3 lots, all non-conforming, created in 1938. Lot 80, 81, and 82. All in one same ownership. At a later time, one in 1939 and one in 1942, a house was built on Lot 80 and half of Lot 81. And then later, a house was built on 82 and half of 81. Those houses were sold to different people, and that remained until my client purchased all of the lots, and then applied to the zoning administrator for a determination that he would be allowed to remove the houses and have 3 non-conforming lots on which he'd be allowed to build houses. Now, the old ordinance, which is not the ordinance now, said that if something was recorded under one ownership at the time of the adoption of the ordinance, then it could be occupied for any use. But that's basically the concept that the zoning administrator applied when he made the ruling that Section 16.1.1 of the zoning ordinance meant that at the time of that ordinance, which was July 15, 1950, lots were of less width and area, but recorded under one ownership at that time, which was not the case here, because they were not under one ownership at the time of the ordinance. But that is not the ordinance that applies. That ordinance that I just referenced was replaced. And section 16.1.1 says that R5 districts where a lot has less width and less area than required in the subject district and was recorded under one ownership on or before July 15, 1950. And that is the essence of our presentation to this board, in that these three lots were recorded under one ownership before July 15, 1950. And that when the zoning administrator said recorded under one ownership at that time, which means July 15, 1950, he's wrong. He's rewriting the code. And the courts have clearly held, without exception, that the legislature makes the rules, and that the court, and that will apply to a board which is acting in a quasi-judicial manner here, cannot rewrite the regulation. The regulation is very, very clear, and it is that if it was on or before. And so when the zoning administrator wrote under one ownership at that time in order to deny our application, the zoning administrator was wrong. I understand the concept. That is, he wanted to say, look, there are two houses, and therefore that's all you can build, because the houses were recorded as by meets and bounds, but the lots were not recorded. If, in fact, my client had removed all the houses and not bothered to ask the zoning administrator, he would have had 3 lots, non-conforming lots. But he asked the question, and he got the wrong answer. And the appeal here is that we apply the code or the regulation as it is written, and that since this was recorded under one ownership before July 15, 1950, we are entitled to the relief we ask. And the relief we ask is that the choice that is presented to the board of 2 resolutions, we ask the board to adopt the alternative resolution, which says that we're right. We have the right to remove the houses, and we can use each of the 3 recorded lots, 80, 81, and 82, as the code or the regulation, the zoning ordinance allows us to do. Conceptually, why was the ordinance changed from the way it had been in 1913, which is the first one I read, and now? And that is because Arlington has a lot of these non-conforming lots. A lot of these times people would buy 2 lots and build 1 house. But applying this new ordinance, it allows them to take the house down and put up 2 houses if it meets the criteria under one ownership at the time it was created. This was one ownership in 1938 when the lots were created, and no one required anyone in 39, 42 to make new lots, to re-subdivide. It never was re-subdivided, and we ask that this subdivision that exists as permitted under the ordinance be enforced, and that the ruling of the zoning administrator be overruled by this board. That's my application.
Any questions, Mr. Freelander?
I have so your argument is that the language today implicitly says at the time it was created?
Yes, ma'am. It doesn't implicitly, it's specifically. It says was recorded under one ownership on or before July 15, 1950. And that's distinguished from the old one, which said it had to be recorded under the ownership at that time, which meant on July 15, 1950. So there is a significant, major difference, and we have to assume that when the council created the new zoning ordinance, that's what they meant, because that's what they said.
But I do note that at the time it was created, it's been added by you, and it's not in the language.
No, ma'am, I didn't add it. I wish that I was that important, but I'm just reading what was written under 16.1.1. That is the way it is written. It was not some inference that I was making to this board. I was reading what the ordinance says, and it says recorded under one ownership on or before July 15, 1950, and we fit that pattern.
Thank you.
Yes, ma'am.
Mr. Melvin?
Good evening. So, as far as like the intention of the regulation, my understanding when there's language like this, I've generally taken it to mean that when the zoning ordinance was passed, you're freezing people's rights. Like if they had a right, then that right is preserved. If it's such and such a way, prior to the change of the ordinance, not taking away people's rights. But what would be the intention, though? It sounds like you're saying that regardless of how early, how many decades ago a lot was created and it's split up and whatnot, but what would be the rationale, though, for preserving that right way back then, regardless of what's happened in the meantime?
To guess by reading the actual language, if you read the ordinance from 1913, where it says, at the time of the adoption of this ordinance, which lot may be occupied, under one ownership at that time of the adoption of the ordinance, which would fit exactly what you are saying. That's setting that right at that moment. The new ordinance got away from that. And the reason, I think, that they did that is because they did not want to make that set in concrete. Theoretically, back in 38 or 42, when these houses were built, they could have required a new subdivision or a re-subdivision to fit the new patterns. That was not done. We still had 3 defined lots, and therefore we don't apply the rulings of the 1913, which says at that time, which is what you're suggesting, but really it is more liberal, and that's by following the exact language under one ownership on or before. And it doesn't say back 5 years or 6 years, it says on or before, and before can go all the way back to 1938 because they didn't put a limit on it. And we have to go by the language that's here, not what we think we would like. We must follow the code. And as you well know, the courts have said over and over, we will not legislate. That's for the legislature. We will follow the clear language, unambiguous language of the code in here of the ordinance.
Mr. Owen?
I have 3 questions, but I'm going to only ask you 2 of them just at this moment. The first is, do you think that Section 16.3.2b of the zoning ordinance is of any relevance? It says that 16.3.2 says, the nonconforming use of land where no main building is involved, existing at the time of this zoning ordinance or its successor, became effective may be continued provided that no such nonconforming use of land or any portion thereof is discontinued or changed, and if so, that any future use of such land shall be in conformity with the provisions of this zoning ordinance.
What was the code section, sir?
16.3.2B.
B, that no such non-conforming use of land shall be discontinued or changed, and if so, that any future use of land shall be in conformity with the provisions of this zoning ordinance. Well, that fits exactly, I believe, sir, exactly what I've said. You go to look at the modern, the new, the 1950, 1950 is modern, but the new ordinance, and the new ordinance clearly says on or before.
But didn't the reality, okay, so I'll hold that in abeyance, and let me ask you my second question, which is, what is the definition of lot that we should be using tonight?
A lot is defined as that which the county has approved. You've got lot lines.
Where
Lot.
Where is lot defined? Is it defined in the code, in the ordinance?
Well, the lot is used in the normal way, is the lot that is approved by the, whatever site plan has been approved by, and it's recorded in the land records. And what is now recorded in the land records is Lot 80, and it's recognized, 81 and 82, they're lots. It's not just wherever your house is. Lot is, that's why you have the number. It's Lot 80, Lot 81, and Lot 82.
So where I'm coming at, my confusion here is that, in fact, the Virginia Code and the Supreme Court have used different definitions of lot. There's more than one definition of lot in the Virginia Code, and I couldn't find a definition of lot in the Arlington County zoning ordinance. And so it seems to me that you're saying that you agree that there's no statutory definition of lot that's applicable to this zoning ordinance, and that we're using the ordinary dictionary meaning. Is that right?
I'm saying that we would have to interpret the word lot to be that which is normally approved in site plans, where you have lines drawn and numbers allowed or provided by the county and recorded in the county land records. Because if I want to know where a lot is, I have to go to the county land record and see where the lot is.
And so you would say that the fact that the lot, the middle parcel here, was divided into two ownerships does not affect its status as an indivisible lot. Is that right?
Because I believe that it never was called Lot 80A or 81A. It was always Lot 81. It never changed its name. Whether it should have been, wasn't. And we take it the way it is now. And that's happened all the way through the county, where you take a house that's been on two lots, and you take the house down, you have two lots. Now, if we take the houses down, we'll have three lots.
Okay. And then my final question, which I'm not going to ask you now, but I'm going to give you a warning about, is that when the county makes its case, they've raised an argument in their written brief that there might not be any logical limit to your argument. And so potentially, because if I understand the argument correctly, and we're about to hear it, that because General Lee had all the property and no zoning ordinance, and he could do whatever he wanted at some point prior to the creation of the zoning ordinance, that would mean that that would render essentially 16.1 meaningless, because you can go back far enough in time to when all of Arlington was a single lot, basically. So I'm sorry, but I just want to preview that so you can listen to the county attorney's correct version of it, because I'm probably getting it a little bit wrong. But I'll probably ask you to respond to it when you've heard it.
Ms. Sanders,
I have it wrong, sir. I think that's
and
exactly
add anything to this conversation?
I'll stand on my brief unless somebody would like to ask some questions.
Did I get it right?
That is part of the way we addressed the appellant's argument, is that it's not logically consistent with what we think the intent of that provision of the zoning ordinance is. This is to sort of preserve in time recorded lots that are under one ownership at the time of the adoption of the ordinance, and to take the appellant's view that it could have been owned, at any point in time by a single owner is way too broad an interpretation. It's not one that the zoning administrator has ever taken consistently since this provision was adopted.
And can you point me to any controlling definition of the word lot?
It is actually defined in the zoning ordinance in section 3.11A1.
Okay.
So established by plat or subdivision.
Correct.
And so do you believe that there are currently is there currently one lot? Are there currently 3 lots or 2?
There are 3 lots. The issue is the buildability of the middle lot and whether or not it retained its use or its buildability, its use for building a single-family residence. That's really the crux of this issue. The local government can't force property owners to re-subdivide their property in the instance that the appellant has suggested.
So what renders the other 2 lots buildable? Is it because are the other 2 lots only
They
built?
retain that non-conforming status as to buildability.
So they're non-conforming?
Correct.
Even though combined with the other parcel, they would be conforming?
Those lots, specifically 80 and 82, yes, they are non-conforming lots.
Is there a conforming lot that exists today in this area in the red dots?
I want to be sure that we're careful to talk about the fact that they are substandard lots in terms of each of these lots lack the required width. I think they are conforming they are standard as to area.
Right.
But the non-conforming piece is to the buildability of them. So each of these 3 lots are substandard, and 2 of them are non-conforming. The middle lot is no longer non-conforming under 16.11.
And so if someone were to remove and try to apply to rebuild 2 houses, would they have to re-subdivide the properties?
I think that it would be a wise move to do. I think that we're getting a little bit into some what-if scenarios.
I understand. This is just so I can understand what the rules are.
So let's say one person had owned all 3 lots since the time of the inception of the zoning ordinance, and they had a house on it, and those 3 lots had conveyed through time.
Mm-hmm.
That one house could come down, and that you could have 3 buildable non-conforming lots. But because Lot 81 was split under ownership, it lost its buildability. It lost its status as a non-conforming lot.
Mr. Melnick?
So I have a question for staff. Is there anything that you could tell us to shed light on the intent of the statute when it was passed? Because Mr. Friedlander was talking about the change in statute from before. And also, if you could shed light, like I see where it says in the particular ordinance, and was recorded under one ownership on, in the languages there, or before July 15th, 1950. And, the interpretation of the county, why or before is in there. Does that just mean, not actually taken to the land records, when the statute came into being, before, but the same owner? But can you shed some light on the intention, any intention of the statute you know about, and also the or before language?
I wish I could, because I wasn't here at the time that provision was adopted. There's no legislative history. I just can tell you that's been the consistent interpretation of the zoning administrator since that provision was enacted.
Other questions? We have 2 other additional speakers. We may be back to you, Mr. Friedlander.
We can circle back and ask.
Did Mr. Owen,
William Lewis, I can't read the writing, sorry. Ohio Street?
Oh, that's me. Lawson.
Lawson? Really? Okay.
Did I write that poorly?
Sorry, Barnes. Okay. Mr. Lawson.
Madam Chairman, members of the board, I don't really have an interest in the case, but it seemed an awful lot to me like Kirkbride. And in Kirkbride, Sue Bell had interpreted the ordinance in a certain way, and we relied on that, and we won our case in circuit court. Went up to the Supreme Court of Virginia, and the Supreme Court reversed it. And they said even though Sue Bell had been doing it that way for all these many years, it was irrelevant. And what the Supreme Court said was the words of the ordinance are to be given their plain and natural meaning. The purpose and intent of the ordinance should be considered, but the ordinance should not be extended by interpretation or construction beyond its intended purpose. And then the case also says, when considering a legislative act, a court may only look to the words of the statute to determine its meaning, and when the meaning is plain, resort to rules of construction, legislative history. Extrinsic evidence is impermissible. So and we lost. We thought it was ambiguous when we went down there, but we lost the case. And so Kirkbride says you got to go with the plain meaning. As far as the nonconformity that you were referencing, Mr. Owen, I would submit that you got to distinguish use versus lot, and that the lot has not been enlarged or altered in any way. The lot has remained the same. You put a house over a lot and a half and another house over a lot and a half, but the lots themselves have never changed. And I would respectfully submit that the lots were grandfathered when they got recorded. And if the county had wanted someone, when they come in with a house built over more than one lot, they would require a plat of consolidation. We do those all the time now. So if you were to come in now and put a house on two of those lots, before they give you a building permit, you're going to do a plat of consolidation. So, again, I don't have an interest in this. I just wanted to share that with you. I have the Kirkbride case if anyone would like to look at it.
Thank you, Mr. Lawson.
Thank you.
Nancy Cardwell.
Good evening. I'm Nancy Cardwell. I live at 1243 North Stewart Street. So I am here to speak not to the legalities of the lotting, but of the character of the street and what would happen if 3 houses were built where 2 are there now. There are 4 primary considerations. It's a lovely tree-lined, shaded street, and 6 of the tall trees that shade that street are on those parcels. I know that tearing down the houses and building just 2 would probably take out some of the trees. Tearing down and building 3 would almost certainly take down all of those trees. It would be a major loss to the block. Also, if you build, assuming that the setbacks, which we just built a house on the left over there, so I know the setbacks, as I believe, are a total of 18 feet. If you take those out of a 40-foot lot, you're going to come up with a 22-foot house. And what has happened is there are 2 houses right there that you can see that have turned out to be very skinny and very tall and completely out of character with the rest of the block and the rest of the neighborhood. They're now 3-story houses, and they're like needles that just stick up. So it would, the footprint, the style, everything would be dissimilar. So that would change the character of the neighborhood. There's a problem with density. There's already parking problems there. If you build the houses at least as most of the newer ones have been built, you end up with shorter driveways, so you're going to end up with more cars going out on the street because there are going to be more houses and more parking and more problems. And the final one is just, perhaps the most important, is the stormwater issue. And simply building over more of the land that's there will be a detriment to all of Arlington County. And so I make my case as an interested neighbor.
Thank you very much. That's the last speaker. For the discussion or questions of the appellant?
Could somebody clarify, is lot 81 conforming as to area? Is it only the width that makes it not?
No, it wouldn't conform to area or width by itself.
So what's the required area, and what area does lot 81 have?
6,000 square feet. 5,000 square feet and 50 feet in width. What does it come out to?
Yeah, R5.
Yeah.
6,200. Okay, so the area conforms, but still not the width.
Okay. In that case, I'm confused because the literal reading of 16.1.1 is where a lot has less width and less area than required and was recorded, et cetera, et cetera. And this does not have less width and less area. It has less width, but not less area than required. So how could we apply 16.1.1?
Because you're not talking about as restrictive. If lot 80 can be built on, and lot 82 can be built on, 81 is the same as the other two lots.
That's not my, well, okay, thank you. I don't mean to argue with you. Thank you for that explanation.
But to address, it says in R5 district where a lot has less width and less area than required and was recorded. I guess the question is, what happens if it doesn't have less width? Does this not apply? Well, if it doesn't apply, then the zoning administrator was wrong to say you can't build there.
Thank you.
Any other comments or questions?
I'd like to staff respond to this issue.
The interpretation has always been that it's an and or, not both. You don't have to meet both if you don't meet either one. Because we're talking about a lot that doesn't meet either width or area. And in the R5 zoning district, you have to meet 5,000 square feet of width and 50 feet of, or 5,000 square feet of area, 50 feet of width. So it was always, you have to meet both of those to create a lot. And this talks about one or the other. If you don't meet them or if you don't meet both, you have to meet both all the way.
I think staff is arguing that it's the way the sentence is constructed, that you have to have both in order to qualify, right? You have to have both width and area in order to
Be considered a conforming lot.
be considered, such lot may be occupied by any use permitted.
Correct.
It's conforming.
Yeah, that you're saying, I think it's sort of a negative here, but they're saying both it's not that both have to be in order to be disqualified, both have to be there in order to be qualified under this ordinance.
The existing lot is substandard in either of those two ways.
That's the zoning administrator's view.
I'm trying to read, the sentence, this is a difficult sentence to read, and I'll read it again some more. I understand your point, but I think the clause is taking us in a different direction. I'll read.
I do think this relates back to the question I didn't let the applicant answer yet, which is, what's your response to the zoning administrator's argument that to give your interpretation to 16.1.1, given the history of Arlington, would render basically the whole zoning ordinance moot because Arlington was once one lot?
I don't believe that Arlington was one lot. I believe Arlington has required people before they build to have subdivisions. You had lots created, and at the time they were created in 1938, they had to meet whatever standards existed, or you couldn't build a house. They met those standards. The county did not require a re-subdivision when the houses were built over lines, and that's throughout the county, because a lot of houses are built on two lots right over the middle. They could have required it, and I think now they do, but they didn't then. And so in 1950, when they addressed this, they were conscious, obviously, because they changed it, not the way it was on the day they passed the ordinance, but before. And I don't think that I understand the argument that you could go way back in time, but we're going back to a time when actual lots were created by the ordinances of the county. And if I could address the other point that was asked, you have a non-conforming lot. You could really be non-conforming if you had neither area nor width. We have area, but we are still a non-conforming lot because we are 8.33 feet short of the 50 feet that we would not need to ask.
Thank you.
Any other questions or comments? Okay, what's your pleasure?
Madam Chair, I'm prepared to make a motion.
Ms. Malice?
I move that the Board of Zoning Appeals make the finding in the attached resolution and uphold the determination issued by the zoning administrator on February 29, 2016, stating that the recombining of the two halves of Lot 81 of the Clarence Ford subdivision would not create a new buildable lot.
Is there a second?
Second.
Discussion? Mr. Owen?
So I feel like we have to either, well, first of all, I'll say that I do agree with the argument Mr. Lawson made that the Virginia Supreme Court has clearly stated that the practice of the zoning administrator or the tradition of zoning administrators' rulings is not really relevant to this kind of interpretation. So I'm not considering that personally. But I do think we have to sort of go one way or the other on the question of statutory interpretation. Either we're going to be completely rigid about looking to the text only if the text has any kind of comprehensible meaning, in which case I think that the appellant loses because the appellant does not have less area than required. Or we examine the statute in the real and actual world and try to divine very basic legislative intent, given the nature of zoning ordinances and their general purposes, in which case I would tend to agree with the zoning administrator, the rest of the zoning administrator's interpretation in this instance, that it doesn't make much sense for in my mind, for the county to have meant at any point in time that any lot was ever created, it can rise from the dead and start being enforced because it once existed. So I don't think I have to pick which way I'm going because both of them lead to the same result, which is that I would uphold the zoning administrator's result. And I'm not saying whether or not I'm upholding the reasoning or not.
Any other comments? I'll call the question. All those in favor of the motion, say aye.
Aye.
Aye. Opposed? Motion carries. Thank you. Next case.
The next case is a deferral. This is V-1088-14-UP-5. And this is a use permit request by Elaine Capusta to permit a setback of 10 feet to the eave, new third floor addition from the 21st Road North right-of-way instead of 25 feet is required. Also to permit a building in excess of 2.5 stories within 25 feet of a street right-of-way. It's for the construction of a new third-story addition above the existing second-story walls. This is in the R5 zoning district. Premises known as 4133 21st Road North.
Madam Chairman?
Mr. Owen?
I move that the Board of Zoning Appeals defer the use permit V-10888-14-UP-5 to the July 13, 2016 BZA hearing.
I'll second.
It's moved and seconded to defer to the July BZA hearing. All those in favor?
Aye.
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 Next case.
Next case is a carryover. This is V-11090-15-VA-4. It's a variance request by John Argelopoulos to permit a total lot coverage of 56.2% instead of 37% as permitted. It's for the construction of a new driveway expansion in the front yard. This is in the R10 zoning district on a premises known as 4741 Rock Spring Road.
Mr. Lawson?
Madam Chairman, because we have a negative staff report, we would ask that you, if you'd be willing to pass this over until Member Smith gets here.
Oh. Why? Because we have 4 people instead of 5.
So that we have 5 members, since we have to have 3 positive votes.
You do? You have to have 3 positive votes?
What is the pleasure of the board? He's requesting that we,
I'd like clarification on the rule. Is it, oh, you
It's,
just,
just- it's because we have 4 now,
in the event that we have a split
Yes, there's a
vote.
tie vote. Mhm.
right? So he wants to be able to add up to 3 with more in the pool. Because it's hard to get 3 out of 4 than it is to get 3 out of 5. I'm not super thrilled about judge shopping like that. I think you take the panel that's arrived.
well, I think at the very least that we would do the same as we do for people who don't show up at all, which is to put it to the end.
But that's when
But
the
that's,
applicant
no,
doesn't
no,
show
the
up.
applicant wants a judge.
I'm just making the point that when we don't follow the agenda for that reason, I don't see any reason, if you agree that you want to not proceed.
We would put it
Mr.
at the
Malnick.
end, but we don't have to agree to that.
No.
I'd be in favor of delaying this until Commissioner Smith arrives, just because, I think it
Okay.
gives
Will you make a
full
motion?
hearing. Yeah. So, Mr. Lawson, are you okay with moving it to the end of the docket?
Yes, sir.
Okay. So I make a motion that in case V110905 VA4, that the case be moved to the end of the docket to be heard.
Second?
I oppose the motion.
Okay. All those in favor? Aye.
Aye.
Opposed?
No?
No.
Tie fails. We proceed.
Thank you, Madam Chairman. Again, for the record, my name is William B. Lawson, Jr., and I represent the applicant. When my client first learned of his illness, he wanted to construct a new garage, and this would allow him to get in and out of the house outside of the weather. He would have a garage on the left side of that house, and he would only have to navigate 2 steps to get up onto the ground floor. We abandoned this request in the face of opposition from neighbors behind us and on either side. When we agreed to withdraw that, we were optimistic that act would be sufficient and that we would thereafter have support of our neighbors. It did not turn out that way. I'd like to point out that when we requested the garage and we requested the driveway leading to the garage, we actually had a coverage of about 8% lower than the proposal you're hearing tonight. Now, I need to go over once again the statute and why we believe we're entitled to this variance. And I think you got to look at the statute in some detail. And what it says is, a variance shall be granted if the evidence shows that the strict application of the ordinance would unreasonably restrict the utilization of the property. That's pretty clear. If the property cannot reasonably be used, you should get a variance. Then the statute says, or that the granting of the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance. Then you have to meet 5 more things. You have to have acquired it in good faith. The granting of the variance will not be a substantial detriment to adjacent property. The condition does not reoccur so often you should amend the ordinance. And it does not result in a use that is otherwise not permitted, or you can't get a use permit for it. So that's the criteria for which one should be entitled to a variance. Now, the hardship here is that the coverage requirements, the county board changed that, and it went from 56% to 37%. And that was done in about 2008. And beginning in 1950 until 2008, it was 56%, so that's like 60 years. And thousands of properties were developed based upon that 56% coverage, including this one. Now, this property today is 46% coverage, so it's already over by 9%. And my client can't put a window well in without getting a variance. And so what we're asking for today is to go to 56%, actually 56.2, which is what was allowed for all those many years. And we think that's a reasonable request. Now, we were unable to come to agreement with our neighbors. I guess there's just too much history between these three families. Because one of the tests is, is this detrimental to adjacent property? I want to talk about the allegation that stormwater, that will be damaging the property downhill from us based upon the stormwater. What I do is I have an email from the engineer that I'll let you all take a look at, and he's explaining that here's what he's explaining. This is the subject property right here, and this is our neighbor. And what the water does, and the property line is way back on that picture. You see that the property line is back here. It's not out here where you think it would be. So the water is draining across this part of our neighbor's driveway. And it does that now, and it'll do it. It'll continue to do that, and there'll be a little bit of an increase in the water that drains across the foot of the driveway. And this land here is raised, so it doesn't go into the yard, it just goes out. Now, this picture here is my house right here, and this is my neighbor's. And I am downhill from my neighbor. I have the same exact situation where my neighbor's water drains across the bottom of my driveway, and then it goes out onto Ohio Street. So that's the stormwater situation with respect to our one neighbor. I'll finalize by saying this, and this is my own experience with my own parents. My parents had a house. May I finish this thought, or should I stop? My parents had a house in New Dover, and they had a circular driveway that went right to the front door, and they also had a garage on the end. You had to go up 2 steps from the garage to get into the house. You had to go up about 5. We always took my parents to the front door using the circular driveway. It was just easier. And my mother was in a wheelchair, and we would actually go up, bump it up the 5 steps, go into the house. It was much easier than fooling around with the garage. And that's why I am sympathetic to my client's desire for this circular driveway. Thank you very much.
Thank you, Mr. Lawson. Questions for Mr. Lawson? Mr. Melnick.
Mr. Lawson, I'm sorry, go ahead.
Okay. So I've got a question. And I brought this up last time, and I didn't know if you could flesh it out at all, but it had to do with the necessity and the circular driveway. We had talked about the elevator, and evidently the house has an elevator, and they were saying that it's not reliable. It breaks, that sort of thing. But I didn't know if, it seems to me, if there's an elevator, unless it's just completely broken or worthless, it seems to me that it could be maintained or repaired. But what are your thoughts about the utilization?
About the elevator in the back? The problem with that elevator is this, and I'll let my client speak in more detail. You can't turn around in the back of this house. So you'd have to drive in, go to the back, and then you'd have to turn around and back out. And the whole reason that John wants this circular driveway is because he has a great difficulty in going back out. And so he wants to be able to come into the property going forward, park in front of the house, leave the property going forward. He doesn't want to have to go to the back of the property, not have the ability to turn around and have to back all the way out. The first time, and I didn't repeat this, but the first time we were here, we talked about the fact that it's very hard to see when you're backing out. If you're coming out front ways, it's not so hard, but when you're backing out, it's hard to see down Rock Spring. Our neighbors may not agree with this, but my client believes it's very difficult to see down Rock Spring, and you also have traffic directly across the street parking for Washington Golf. And so that's why my client believes it's very important for him to be able to enter the property going forward and be able to leave the property driving forward, one continuous going forward. Does that help?
Yeah.
Thank you, sir.
Ms. Alice.
Can I, Mr. Lawson? The doctor's note that was submitted to us says that in the near future, your applicant will have to use a walker or a wheelchair for mobility. What are your thoughts about those stairs in the front of the house?
Well, again, from my own personal experience, you can if he's in a wheelchair, you can, back it right up those steps, which is what I did with my mother. He also has the ability to put a ramp in. And I sent Mr. Knox an email, and I have it in my file. I didn't copy it to hand out, but there are those little elevators that will run you right up those steps. And they're for outdoors.
Yeah.
And he hasn't designed that because, frankly, he didn't want to spend the money on that unless and until he got the variance. But there are companies that he can work with the engineer and design it so it'll lift them right up. Or if you have someone with you, they can just back the wheelchair right up the steps.
So you are requesting a variance in order to meet ADA mobility requirements?
Yes, ma'am. Well, I think we were entitled to the variance anyhow. You all did not agree, and then we came back believing that under the ADA we're also entitled to it.
So you would be satisfied with an ADA compliant solution?
I'm sorry?
You would be satisfied with an ADA compliant solution?
If it allows him to drive and egress his house using a circular driveway, yes.
Mr. Allen.
I have a question for the zoning administrator. We were preparing for the last hearing. The main argument that was presented by the zoning administrator was that the applicant had not met his burden of production to demonstrate a disability. At the last hearing, the applicant did present a medical opinion that appeared to be pertinent to at least part of what's being requested here. In this report, it didn't seem like the argument that you were making about not having met the burden of production had changed very much. And I just wanted to get clarification. Are you still asserting that the applicant has not met a burden of production to demonstrate, to assert, to do more than assert, but has in fact provided evidence tending to show that this would accommodate a disability?
I would say I don't believe it does. Our ordinance has provisions for ADA-compliant ramps and similar structures, which would allow him to access his driveway from the front door. We don't feel that the driveway is that end.
But do you still believe that he hasn't submitted enough evidence to show a relevant disability? Or do you concede that the applicant has now offered sufficient evidence to show a relevant disability?
I think they've showed that, but I do not believe that that is what this board is supposed to hear. We have criteria under the Code of Virginia for approving a variance, and that is what we stick to.
Okay.
Could you elaborate on that? Could you elaborate on your answer, Mr. Knoxon, that the Code of Virginia, that we're following the Code of Virginia and that we're looking at economic hardship as opposed to a mobility issue? Is that what you were implying?
No, I wouldn't say that at all.
Just to get back to the question that Board Member Owen was asking, I think at the time it was written, I don't know if we had received this information, so we were satisfied that a demonstration of disability or the need has been provided, but the other two parts that are addressed in the report are, now that the disability has been demonstrated, the decision now is about whether or not the accommodation is reasonable and necessary. And so that's the next step that has to be met. And so that's where I think the discussion is now about what he's asking for and whether those changes are reasonable and necessary given the disability.
Can I ask one more
Yes.
question? Mr. Lawson referred to some communication with you regarding the elevator, or did you not say that you had the lift?
Oh, yeah.
Yes, we did have some discussion about that. What I had done is asked Mr. Lawson for some sort of plan, just illustrating either something on the plat or some drawings showing potentially what could be constructed
Right.
attached to that driveway. And we haven't received any sort of plan showing that.
Well, I didn't submit a plan because my client didn't want to spend the money unless he got the variance. What I submitted was a brochure, and I said that if this were granted, then we would do a plan. But, I mean, it's pretty obvious from looking at the brochure that it would be a ramp like the one down on the ground floor that goes up those couple steps. It would just go right up those steps, and it would take you to the front door.
Do you agree that it's very important that this be ADA accessible with either a ramp or an elevator?
Yes, ma'am.
All right.
But as I understand those lifts, I've seen them used many, they would be of no value whatsoever without the driveway, because the lift is simply an alternative to the stairs of going from the driveway, proposed driveway, up to the entry level.
Okay.
Other questions, comments? We have some speakers. The applicant himself put in a speak. Do you want him to speak as well, Mr. Lawson?
If it's the board's pleasure, but I think you need to hear from him to understand what he's going through.
Okay. Mr. Argelopoulos?
Come on up.
I also have a speaker slip from Demi, who's requested to speak last, which is all right, all's well. And there are two additional speakers. Come ahead, please.
My name is John Argeropoulos. I'm the owner of the property. A ramp, if you built a ramp along the front of the house, it would only have to raise up about 36 inches. That, I think the code is 1 inch per foot, the slope. If you try to get a ramp from the driveway to the first floor of the house, it would have to be 120 feet long,
Yeah.
which means it would zigzag. It would take up the entire yard of the house, zigzagging back and forth. But if the ramp was going from the front door to the left, the house is 40 feet wide. It would extend maybe 15 feet into the yard, and then it would travel along the front of the house or you could have a lift go straight up the stairs. But it's pretty simple to build a 3-foot ramp as opposed to a 10-foot ramp. That's really all I have to say.
Thank you. Alan Dwyer?
Good evening. My name's Ellen Dwyer, and I live at 4747 Rock Spring Road, which is the property to the left of the picture that you're looking at. I wanted to just talk about two things. I've been here every month that we've discussed this case. I was here when the BZA denied this application in February. I was very disappointed, actually, that we've not been able to reach an agreement about this. I opposed this. In February, the BZA denied the application, as Mr. Lawson said, The applicant came back citing the ADA and FHA as a basis for proceeding. And we, at the last hearing on May 11th, reached an agreement with Mr. Lawson and his client and in writing about the various things that we were going to work together to come up with a plan. There were very specific things that were reflected in the agreement that we signed off on that would have to be reflected in a plan that would be acceptable to all. There was no commitment as to the detail of it, but there were elements that we agreed to. Two of the elements, one was that any plan would include a tree preservation plan to preserve and protect the holly hedge, which runs the length of the property line on the Dwyer side of the property. And then the other piece was that there would be a stormwater control plan to mitigate water coming off that ledge of the property. And Mr. Smith, I assume, is going to speak to that side of the property. We engaged last week. I was communicating with Mr. Lawson about, is there a plan? I received a plan on June 7th. We looked at it. We proposed some suggestions to it. The plan as proposed did actually include a tree protection provision. And then I learned on Friday that that was no longer acceptable, at which point there was no further need to be talking to each other. We were told by Mr. Lawson that we saw in the plan all of the accommodation that the applicant was willing to make. So that's where that ended. I think I'm here today, and I believe Mr. Smith is as well, prepared to talk about and to address and negotiate and see if there isn't a way to work this out, but we've hit a wall on that. The second issue that I wanted to address is the issue about the ADA in particular.
Your time is up. Would you sum up, please?
It is the necessary point. That is, it is not sufficient to be able to identify an accommodation that is preferable. The accommodation and the need for the accommodation has to be demonstrated to be necessary. And there are a number of alternatives here, which I will just identify, that would afford the applicant access to his property through there is a ground level elevator. There is ground level access to this property today. This is the basis on which the BZA ruled in February. We provided on May 24th information to Mr. Lawson that included the name of elevator repair companies to facilitate having some examination of that. And as to this turnaround issue, the space behind which the county notes it's roughly a 1,600 square foot asphalt space for a vehicle to turn around. That may or may not be acceptable for an Escalade, but certainly there are other vehicles that could turn in that space.
Thank you.
Okay. The last thing I would say is that there is
Andrew
another
Smith?
option on the plan as submitted, option B, that I'd ask you to consider.
I'm sorry. I'm going to call her back because not later.
Good evening, members of the board. I live at 4733 to the right. Conceptually, I have no problem with the driveway. My issue is really, we're looking at a flat table plan. There's no grading, no attempt to show grading. I disagree with Barnes's description of how the property drains. I live there every day. Conceptually, the driveway is fine. If John needs it to get up to his front door and so forth, that's fine. We tried to have a discussion to say, okay, if you grade it, if your driveway's going up, pitch it, so forth and so on, to keep the water generally directed that way. If you run a basic calculation of stormwater runoff, there's two factors: what it hits and how it runs. What it will be hitting is hard surface, nothing to absorb, and it's on a pretty steep slope. What it means is it's shooting more or less straight across. Our driveways are relatively flat. It pitches from the corner of John's house to the corner of my driveway. It's a pretty slow slope. So what I'm afraid of is water's going to come straight across into my yard. What I would request is that if an approval is found necessary to accommodate John, that it just conform to the standards of DES within the county and T&EO. That's all I ask.
Two acronyms? What do those two acronyms stand for?
Department of Environmental Services that reviews site plans. And T&EO is, I forget, I've been using that acronym forever. They review the curb cuts and so forth for entrances.
Okay.
Thank you.
At this point in time, we have no assurances of anything with respect to what's shown as a flat plan with really no design. It's a plat.
Thank you. Demi Argyropoulos?
Hello, my name's Demi Argyropoulos, and I'm the applicant's daughter. I don't really have anything to say in addition to what I provided last month about my dad's disability. Although I do think it would help a great deal. I think that was an argument that was made secondary because the driveway was initially completely rejected, and I think that disagreements with the neighbors for as long as I've lived in that house as a child, it have kind of just overtaken, and the opposition isn't about a driveway, it's about just kind of having some leverage to kind of hold approval over our heads, because I know Mrs. Dwyer wanted a 5-foot limited disturbance zone between the holly hedge, which is 20 feet tall and you can't see through. So I'm pretty sure that may qualify as a fence and be against the zoning ordinance. But it just seems very tactical, and it's unfortunate because I don't think the runoff, I mean, that's science, that is a valid point. But the trees, I mean, we are completely open to screening, but that doesn't mean a 15, 20-foot tall hedge that the driveway could obstruct the root system to. So it just seems very underhanded, and I guess that's why I'm getting worked up about it. But that's all I have. So, thank you.
Thank you. Questions? Comments? Ms. Malice?
Could I have permission to recall the first speaker, the neighbor that went over? She mentioned a plan that I didn't quite catch.
Okay.
If she wouldn't mind coming up. At the end of your testimony, you referred to a plan.
Right.
What plan was that?
Submitted with the application. The proposal is for a 944 square foot circular driveway, and there was an option B in the plans that have been submitted and are on file with the county, and that is for 544. It's a stub driveway that does not go all the way across the property. That's what I was referring to as an alternative.
Was that an alternative proposed by staff?
That was by the applicant.
Okay.
There's some mention of it in the report as a second option, in case the board wishes to approve a lesser variance.
Okay. Thank you for clarifying that.
Well, could staff clarify the coverage that would obtain if option B were adopted? What would be the percentage coverage then?
52.4% would be option number 2.
Thank you.
Thank you.
I guess I would just say in response to the comments, there's no ill motivation here. I would like nothing more than to be able to reach an understanding so that Mr. Argyropoulos could have a driveway that would suit his needs. This is not about that, but we have holly trees that are valuable that are on our property, that if there is a driveway that's constructed that kills the roots to the trees will all come down. This is not personal in that respect. Thank you.
Thank you. Any other comments or questions before we have a motion? Mr. Owen.
So I'll just lay it out there so that you guys can figure out what adds up to 3 votes, if anything. I think Mr. Argyropoulos got his money's worth from his lawyer, because I think that Mr. Lawson has presented to us exactly what I think is necessary under the supremacy clause of the U.S. Constitution, which means the ADA controls what we do here. And he has provided us with, has met his burden of production to show that there is a disability that needs to be accommodated, a disability to be accommodated, that the nature of the disability is that Mr. Argyropoulos needs to get to work using a particularly sized work vehicle and has presented a doctor's note saying that he cannot operate that work vehicle in order to get to work out of his driveway because it's hard to turn around. And so this, I believe we have what, in my opinion, what we need to justify granting a variance solely to turn the truck around. I think that's something that we need to do. Now, I agree with the zoning administrator that it has to be a reasonable accommodation, perhaps the minimum reasonable accommodation. And I have my own notions about what that will be, and I'm not super confident that any three of us will agree on what it'll be, but we'll see. But for me, one thing at a minimum is I would want to see a stormwater mitigation plan at a minimum. And to my mind, the purposes of the zoning ordinance, which we are required to consider in granting this variance for coverage, are multiple. One purpose of limiting coverage is aesthetic. Another coverage reason is for vegetation, I suppose. Stormwater has at least two reasons to be included. One is runoff directly to an abutting neighbor or other neighbors nearby, but the other is just the stormwater system. There's a public interest in not having water run off into the street. And so irrespective of what neighbor is and isn't, I'll even take Mr. Lawson's argument that it all runs off into the street, but to me that's not sufficient, that's not reasonable. That it's incumbent upon the applicant to produce a stormwater mitigation plan. So I would not approve this variance unless the applicant was agreeing to stormwater mitigation. And then furthermore, and I briefly mentioned this at our last meeting, because I do think we have to accept doctor's notes like this in order to grant variances under these kinds of unusual circumstances. I've thought a lot about what's a reasonable condition to not run the risk that doctor's notes will completely erase our entire zoning ordinance, one house after another. And so my personal view is that the variance should expire a reasonable period after it's no longer needed to accommodate a person with a disability. And so I would only be inclined to support the variance if such a condition were put in place. And I would propose, although this part is arbitrary, 2 years after it's no longer needed to accommodate a disability is an appropriate time for it to expire.
You suggesting that the driveway, if it was put in, would be removed?
That's exactly right.
And which of the two driveways do you like?
I just would say the variance expires, and so...
But do you have an opinion about the driveway?
Oh, about which of the two driveways? I mean, I don't think there's any dispute that option 2 or option B would be sufficient, so I would support the smaller one.
Comments? Ms. Malice?
I tend to support what Mr. Owen has laid out. I think the one addition that I would add to that is that indeed a disability has been shown, but I think that true ADA accommodation is either a ramp or a elevator to the front steps, and that would be a requirement of the variance, and that my approach to the length of the variance might simply be so long as that ramp or elevator remains in place, the variance is serving its purpose. If at some point the ramp were to be removed and or the elevator was removed and it was no longer handicapped accessible, then I think the driveway would go too. But I do agree that there has to be a stormwater plan, and I'm a little concerned that we can decree it here by saying that we're not passing the variance, but there has to be a process in which it's actually created and examined and determined to be acceptable to all the parties, and I'm not sure how that process would play out.
Well, I have a question. We can tack that on. But what is our experience, if any, with time limitations and removal requirements for so-called improvements? And with Ms. Malice's question also about whether or not we can require what sounds more like a site plan condition to me, but that's one of my other lives.
We have had experience with one particular use permit. It was for detached storage shed, and there was a sunset period of 5 years. It was for housing legal documents that had to be kept for, however many years, and he said he needed to keep them for 5 more years, and they said after 5 years, it must be demolished. As to stormwater component, I think that's going to be harder to enforce without getting DES, Department of Environmental Services, involved with it. Typically, they're not going to review that type of plan unless you're disturbing up to 2,500 square feet. But we can certainly talk to them and see what kind of input they can have on a smaller such plan.
So you wouldn't suggest it just as a condition of a resolution?
If we did, I'm not sure how enforceable it is at this point without having some input from them.
Yeah.
Personally, I think that removing a driveway, even half a driveway, isn't really comparable to removing its shed.
True.
Which could be whacked
This
down
is going to
in
take a lot of retaining walls and other structures to...
I just don't think it's practical. I get the intent, but I think as a matter of who owns the property next and who keeps track of it to begin with.
So can I ask the applicant a question? Mr. Lawson?
Mr. Lawson.
It is your position that you will do no stormwater mitigation?
We actually had the engineer look at it, and we're not trying to be stubborn. But according to our engineer, there's just not enough area to practically do it. Remember that a lot of that is not his front yard, it's street right-of-way. And the only place we could really put it if we were to do it would be partially in the right-of-way. And when I had Mr. DeLashman look at it, he said it would just be really, really difficult to do this. And I would also submit that if we're going to have to take the driveway out, I don't think we should have to do the stormwater as well.
Okay. So would it, if we were to encourage you to develop a stormwater plan, would that be wasting our time and your time?
Well, I can't say that for sure, but I'm not sure that the applicant would proceed if that were a requirement. It may actually not be possible to do it. We looked at it at the request of Mr. Smith, and according to our engineer, it would just be really difficult to do.
Would you be willing to look at the opinion of a different engineer that was supplied by the neighbors?
Than our engineer? Hmm? Well, I don't like to ever say no to a request like that. This particular engineer is about as good as they come.
Are you open to another opinion? Or, we just need to know if there's any movement here or if this is...
Well, I mean, if that's the only way that we can get the approval, then we would certainly look at it in good faith. We'd prefer not to.
Mr. Lawson, the stormwater, I think as I understand, you're saying that the stormwater runoff produced by this improvement would be difficult to mitigate.
Well, it's very minimal, and it would be difficult to design something that would, I don't think it's
I'm sorry, if I could just interject.
It is going on to his property.
Yeah.
I think Mr. Smith is more concerned that it not come on his property than that there be stormwater.
I really don't,
Sit down, please.
I'm sorry, I just don't want to get into that because that wasn't my question. What I was leading up to was my concern from the standpoint of the public is reducing the load on the overall stormwater system. And so I would potentially be satisfied by a stormwater mitigation that mitigated stormwater runoff from some other part of the property, like the roof of the house, and not specifically the runoff from the driveway.
Those, one of those, what do they call them, holding ponds?
Right, or rain barrels or whatever.
We could look at that. I would ask that if that does happen, that we not have a sunset. because those are a lot of money. They're $10,000 each.
Thank you.
Other comments, questions?
So I'm a little confused. Which neighbor gets the runoff?
The
Which
one,
of the applicants?
the one on the right. That's right.
Yes.
Mr. Smith.
May I call him back? I'm just interested in
Mr. Smith?
his expertise. Are you able to secure your own engineer to evaluate the situation for your property?
Certainly can. But the water comes across my property as it is right now. What I'm trying to avoid is the water shooting off into my front yard because of the slope and the quantity. Roughly at about an inch of rain per hour, it's an additional 300 to 400 gallons that are going somewhere. And that's a very simple stormwater calc. Engineers do it in a much more precise way when they go back and forth with the Department of Environmental Services on larger site plans and so forth. It's going to come across my driveway and so forth. That's fine. I just don't want it running up into my grass and turning my front yard into, soft soil. That's all.
Okay. But you would be willing to employ your own engineer to come up with solutions since...
Personally, I don't think I should have to spend the money, roughly $1,000 or so, to fend this off. I don't feel the burden of proof is on my side. And again, it already comes across my driveway, and that's fine. I've got a video on my phone if you would like to see it. Gentle rain and so forth is not a big deal. When we get heavier rains in approaching like a 10-year storm event, then it starts to shoot a lot of water my way. That's all.
Okay.
Thank you.
May I ask Mr. Lawson a question too?
Mr. Lawson?
Mr. Lawson?
Yes, ma'am.
Regarding the tree protection on the other side of the property, what is your position there?
Well, my client feels that it's getting so large that it's starting to overwhelm his property. He said he would be willing to put up a fence or some shorter shrubs, but these are, according to him, they're just getting really out of control and kind of taking over his property. And so...
That the existing trees are...
The existing tree line that is in between...
He's not interested in maintaining it?
No, ma'am. He would prefer not to have to preserve that.
And is that on his property?
I'm sorry?
Is that on his property?
Well, they're
trees?
partially on his and partially on Ms. Dwyer's. And they're way over on his property, quite a few feet. And so when we talked about that last night, he felt like it would be giving up an awful lot of his property, and it's shaded, and he's having trouble getting grass to grow. And so he would be willing to provide a buffer. He just doesn't want to be obligated to not use his property within 5 feet of the property line, is what he said.
And what kind of buffer is he proposing?
Well, he could do a fence, like a solid wood fence or smaller shrubs, something like that.
I mean, is there a specific proposal that we could act on?
We don't have one tonight, no, ma'am.
Okay. You ready to move along?
I have a quick question.
Mr. Melnick?
Is there, I've heard everything that's been said, and I'm, definitely leaning toward Plan B, the 544 square feet. But I understand about the flow of water and all that. How about I know sometimes driveways, they can be graded, they can be slanted, there can be little barriers, curbings, something to guide the water, toward the street, and so it doesn't just flow over to the neighbor. But has anything like that been looked at? Any kind of structure, little structures out of concrete or asphalt, some way?
That's what Delashment looked at. And the problem is apparently you can't pipe it to the street and then let it go. Under current regulations, you can't do that. And so that's why we were unable to accommodate the request. The request was to capture the water at the foot of the slope and then move it out to the street and then let it go out on the street. And according to Delashment, the county won't let you do that any longer.
And that would even be to the point of putting up a curb, anything that collects it and makes it flow to the street that way.
Put a curb right along the property line?
Yeah.
We could probably do that.
But you can't put...
The only thing I would worry about is you might bang into it or scrape your car, your wheels or tires or something. But a curb could be put right in the middle of the driveway.
Yeah. And I haven't been there personally, so I don't know if that would actually do any, how much that would do toward making the water, it seems like it would be a barrier to the neighbor, but whether the water could actually be then, made to flow to the street.
It would flow down my client's driveway, and then it would go out onto the street. The reason we didn't propose it is we were fearful that we would run into it, and that, some guest comes and bangs into it and damages their car, or knocks it over or something. That's why we didn't propose it.
Mm-hmm. Okay, thank you.
But we could do that.
Ms. Malice.
Lawson, is Plan B acceptable to your client?
I'm sorry?
Plan B acceptable to your client? Mr. Melnick referred to...
May I confer with him for just a moment?
But then he's got to back up. Plan B makes it, he has to back up on Plan B, doesn't he?
We need. For purposes of discussion, I'd like to make a motion.
We might as well wait for the verdict here. He doesn't like it because he has to back up.
He would prefer the entire driveway.
Thank you.
Okay.
Mr. Owen.
So I'm prepared to approve the variance, but I am only inclined to approve the variance if there's this 2-year or similar expiration. And I don't know that I have the votes to get that in there. So in order to move us along, I want to figure out, I think I make a motion and then I'll offer an amendment so that we can have the vote separated out. I'll probably oppose my ultimate motion, but I just want to get it moving. So I move the alternative resolution in page 9 of the staff report with some amendments. I move that in item number 1, that are we calling it option 2 or option B? What's the name of it? Option 2? So I would say after the word in accordance, I would add the words with option 2. With the footprint shown. And then I would add one additional condition, number 3. No, let me just make that motion. So I'll put that forward for purposes of discussion, see if it gets a second, because I have 2 other additional conditions before I would be willing to vote for it.
Clarification.
So I'm moving the staff report, but with option 2.
Which one's option 2?
Yes. That's the one with half a driveway.
Half driveway.
Yep.
The staff report is to deny.
Page 9 has an alternative resolution that I'm moving,
Okay.
and I'm inserting option 2.
Option 2 would be 52.4% coverage.
Right. Yes.
I'll second.
Okay, so now I'd offer an amendment to add an additional condition as follows. Number 3, the applicant agrees to obtain the zoning administrator's approval of a stormwater mitigation plan sufficient to retain stormwater equivalent to at least 15.2% of the parcel and shall construct and maintain the improvements in such approved plan. So basically, I'm saying to the extent they're over the ordinance, they have to find someplace on the property to store stormwater. So that's my motion to amend the main motion.
Is there a second? Okay. You ready for,
It's the main motion's for discussion, and now I've offered an
the
amendment.
resolution
We're going to vote on the alternative now.
as amended with the stormwater mitigation?
We're going to,
No, now the main motion is with option 2, and I've moved and we moved and seconded for an amendment, so the amendment is pending for a vote.
Okay, so the amendment is on stormwater mitigation.
Yes.
All those in favor?
Aye.
Opposed? No.
Motion fails, right?
Motion fails. Now we're back to the
An
main
additional
motion.
amendment. Number 3 would have been number 4 if that had passed. The applicant agrees that this variance shall expire 2 years after it is no longer required to reasonably accommodate a resident with a disability.
Is there a second?
Didn't expect it.
Lack of a second.
Thank you.
You want to vote on the motion?
I have an amendment.
Ms. Malice.
So, as I understand it, we are voting on the stub, which I cannot support because I think the doctor note has said that he needs the full driveway in order to be able to maneuver his vehicle.
And the applicant doesn't support it either. Okay.
So I guess I don't have an amendment to this
So-
particular.
Right.
No, I can't. You can't amend to reverse.
Let's dispose of this motion first. Alternative resolution. Plan B. All those in favor? Opposed? No. Okay. What's next?
I would make a motion,
Ms. Malice.
accept the alternative resolution with amendments, with conditions. Number 3, to have a stormwater plan approved by the zoning administrator that would mitigate the stormwater runoff resulting in the increased coverage. And number 2.
And is that Plan B?
Sorry?
Is that Plan B or just?
I'm sorry, I'm on option 1.
Okay.
Option 1, so that's the full driveway with the stormwater plan. With tree, the next one would be a tree protection plan that would preserve the existing foliage along the property line. And the additional condition would be that the variance is granted so long as an ADA compliant handicap ramp from the drive to the front steps or a ADA compliant elevator to the front steps is maintained.
Is there a second?
I'll second.
Moved and seconded. All those in favor? Aye. Say aye.
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 Opposed? No. Fails. Anyone else have another idea? Mr. Melnick.
I would like to make a motion, the same exact motion as Ms. Mellis made, but without the sunset provision.
Is there a second? Hearing none, fails for lack of a second.
I move to, I'm going to move the zoning administrator's recommendation.
I'm sorry?
I move the denial resolution on page 8 of the report.
Is there a second? I'll second. All those in favor? Aye. Opposed?
Aye. No. No.
Aye or no?
Well, I'm voting against the motion.
No.
You voted no.
I know.
Okay,
Well,
even though
I'm-
you made the motion.
I know.
So in other words, I'm voting against the motion of denying the variance.
Right.
Right.
Okay, so we have no action.
We have no action here.
Do we want to just take a deferral at this point?
I guess we ought to discuss what elements ought to change before we can reach some consensus.
To be honest, I think the appropriate thing to do is for us to, maybe for us to wait until we have a complete, what is it called? Bench. We might get to 3 votes more easily if we have another person.
I will tell you that in order to approve this variance, it has to serve ADA compliant aims and goals. Just simply to have put in a driveway is not sufficient. I would not support anything that was not ADA compliant, either with a elevator or a ramp. I think that's to me the element that justifies this significant departure from the law that we have right now. Others, I guess I'm putting out sort of my bottom line here, but others may have their own bottom line in terms of what they will or will not support.
Mr. Melnick?
And my motion about the everything except the sunset provision, I just think that'd be a hardship, to have to rip up a driveway, and how do you enforce it? What does the county do it if the homeowner can't afford it? So that's the reason I made that motion, just due to hardship and enforceability.
Well, we have a full agenda, so we have to do something.
We just move on.
The staff has a suggestion. What do you suggest if there's a stalemate?
Good. I think we can just move on.
Move on, there's no action.
We take no action. I move we move on to the next item without taking action on this item.
May I? Should we ask if the applicant wants another deferral to try to work this out further?
Well, what happens if we don't take action and we simply move to the next agenda item? What happens to this request?
I think if there's no action taken, that's the same as a denial. They'd have to make another application.
But it's not with prejudice. Denial would be with prejudice. This would be without prejudice.
Yeah, I do think that we've laid out the elements that we're interested in, and I think the applicant can look at sort of how his proposal stacks up against our thoughts here and make a decision as to whether there's further action that he would take to sort of meet some of our concerns.
Okay.
I guess we requested deferral.
May I?
Yes.
Mr. Lawson, would the deferral be until the July meeting, or when do you think is reasonable? July? Okay.
Board's pleasure.
Yeah, I'd like to make a motion. Okay, so in the Board of Zoning Appeals case V1109015VA4, I make a motion to defer this case until the July 2016 Board of Zoning Appeals meeting.
Is there a second? I'll second. All those in favor? Aye. Opposed?
No.
I vote for my own motion. That's what you're saying.
Okay, but it fails. We might have set a record here. Next case, please.
The next case is V-11133-16-VA-1. This is a variance request by Arvind Nandekar to permit a total lot coverage of 37.4% instead of 35% as permitted. It's for the construction of a new one-story front addition, a new front porch, and a new one-story rear addition. It's in the R10 zoning district. Premise is known as 3506 25th Street North, and the motion is to withdraw this case.
Mr. Chairman,
Yes.
I move that the Board of Zoning Appeals withdraw the variance V-1113-16-VA-1.
Is there a second?
Second.
Okay. All those in favor,
Aye.
say aye. Anybody opposed? Okay, that carries. Please call the next case.
Next case is V-11133-16-UP-1. This is a use permit request by Arvind Nandekar to permit a setback of 23.6 feet to the addition, 18.1 feet to the eave, and 18.6 feet to the porch space from the 25th Street North right-of-way instead of 25 feet as required. It's for the construction of a new one-story front addition and a new front porch. It's in the R10 zoning district. Premises known as 3506 25th Street North.
Is there any questions of staff on this case?
No.
Hearing none, could we hear from the applicant, please?
Thank you to the board members for the opportunity to present this case and zoning staff. We reaffirm everything we had submitted and everything that was found by the staff and the staff report. One of the things I wanted to point out, and I might need clarification from staff, I know the setback is 25 feet, but I believe you're allowed to encroach to 21 feet with a porch on the front. Is that correct?
That's correct.
Okay, yeah, so even though the minimum is 25 feet, we're not asking, I guess the difference would be roughly about 7 feet is what you would think we're asking for, but again, you're allowed to encroach to 21, so really we're asking for less than 3 feet of encroachment in the front by right. This is kind of a necessity, well, I would say definitely a necessity. Mr. Arvind Nandekar and his wife are elderly, and they are doing an addition off the front in this proposal. The addition is to kind of create a new enclosed area, and so that we can create stairs that are about 6 inches tall, going from the front of the grade all the way up to the main level of the house. So that was actually the necessity for the structure, is to create stairs that have lower height, tread heights. When we originally started this, that's why we had to cancel out the original applied variance. We found out we were over the lot coverage. We have remedied that by making some alterations to the existing areas on the property to fall under the maximum allowed. So with that, I leave it to you for any questions you may have of me.
Questions of the applicant?
Have you shown this proposal to any of the neighbors?
Yes, and I apologize to the board. I was late in getting that to staff, and I did give it to them, and they asked me to make copies and get this to you guys.
It's okay.
I will note, I tried to get the 5 main neighbors, the 1 on each side and the 3 in the front. It was difficult getting the neighbors on the side, but from what I understand, I believe the owners have talked to the neighbors and they don't have any issues with it. So the neighbors that are most impacted, in my opinion, would be the neighbors directly in front who have to stare at these structures every single day. Those 3 did sign off on it. I will note that the neighbor on the, if you're staring at the front of the house to the right, I believe, I apologize, see if I can grab that address.
2421?
They are, I'm sorry, at 2421 on the corner there, the back of their house actually faces this property. So I don't think they're really detrimented by this. And then I had seen the picture that was originally up on the screen. I think that's a little bit older of a picture, because if you're staring at the house to the left looks nothing like the one in the picture. It's been redone completely. It's quite a large house, but it's slightly angled away from this property. So they actually wouldn't even see the front of this house if they stepped out the front of it. They'd have to kind of turn back a little bit to even see it. So, and in fact, that looks to me like the front of that house is closer to the front than what we're asking for. And we're not arguing with that. We just making a note that that is the kind of the existing site condition next door. But again, from what we understand, no one seemed to have brought up any issues with it.
Excuse me, I was out of the room. What is your name, sir?
Skylar Aarons.
Okay, because I have your speaker slip, and I just wanted to make sure that I wasn't going to call someone. Thank you. Any questions? The applicant?
Madam Chair?
Mr. Mouse,
Make a motion.
please.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V11133-16-UP-1, subject to the conditions listed in the resolution.
I'll second.
It's been moved and seconded. All those in favor, say aye.
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 Opposed, nay. That's approved. Thank you.
Thank you to the board.
Next case, please.
Next case is V-11134-16-UP-1. This is a use permit request by Peter and Monica Irvine, and this is to permit a setback of 3.7 feet to the second-story eave, 4 feet to the eave, and 5 feet to the wall of the new two-story addition from the right side property line instead of 8 feet is required. 8.8 feet to the second-story cantilevered addition from the left side property line instead of 10 feet is required. And also an aggregate side yard of 12.5 feet instead of 18 feet is required. It's for the construction of a new two-story rear addition, a second-story rear cantilevered addition, and an eave overhang for a new second-story addition above the first floor walls. This is in the R6 zoning district, premises known as 4901 16th Road North. The motion is to defer this case to July 13th.
Madam Chairman,
Yes, sir.
I move that the Board of Zoning Appeals defer the use permit V-11134-16-UP-1 to the July 13th, 2016 BZA hearing.
Second.
Moved and seconded. All those in favor? Aye.
Aye.
Thank you. Next case, please.
Next case is V-10961. This is 14-UP-2, and this is a use permit amendment request by David and Rebecca Clifton. It's to permit a setback of 12.6 feet to the stormwater planter box, 16.1 feet to the eave, and 16.4 feet to the wall of the screened porch, the 19.6 feet to the eave and 19.8 feet to the open porch base from the 26th Street North right-of-way instead of 21 feet is required. It's all for the construction of a new left side stormwater planter box, a front screen porch, and an open porch on the left side of the home. This is in the R6 zoning district on a premises known as 6225 26th Street North.
Thank you. We hear from the applicant.
Hello, I was here a year and a half ago with this, and you approved the plan as is. Shortly after you approved it, we went full term with our architect to get plans for bid and build. That was approved, submitted by March, and I had contractors selected and everything, so permits were applied for. Due to financial reasons, we split the project into two pieces, the main structure and then the porches, because coming from, I was a landscape architect, and I was really worried about cost overages, and so we just didn't feel that that was a risk we were willing to take. So we built the structure first. Our contractor came in on time and on budget, surprisingly. After 15 years in the field, that still amazes me every time it happens. And so when we went ahead to build the porches, we were told that we needed to see you again. The only difference between the application we previously sent you and what you're looking at right now is that we've been required by DES to include a stormwater planter box in the front, which is now outside of the setback, or within the setback.
Okay. Any questions? Ms. Malice? Oh, thank you. Question of staff?
Mr. Noxon, in the staff report, it wasn't clear that the stormwater planter was required by DES. It just said it has been proposed.
Mm-hmm.
Is that required by DES?
I'm actually very surprised they required this. Typically on smaller projects, they don't require something like this, but it seems that as of recently, they are requiring these for smaller projects. Usually it's 2,500 square feet. If you disturb that, you have to add those.
With the project up, we were told that we could submit for it afterwards, and
Okay.
that would not be a case, but then we went back in and resubmitted, and they're including any improvements over the last 2 years that in that square footage. And so even though everything else is currently built, we have to include it. So unfortunately, I would prefer not to have it, especially coming from as a landscape architect. There are a lot of troubles with these boxes, but if it's what we need to get the porches up, we'll gladly take it.
The requirements have tightened up in the last couple of years.
They have, and they, for better or for worse, yes.
Okay, thank you. Any other questions? There are no speakers.
Madam Chair, I'm prepared to make a motion,
Please.
if I can find it. I move that the Board of Zoning Appeals in the case B-10961-14-UP-1 adopt the attached resolution granting the subject use permit, subject to the conditions listed on the following page. That would be page 5.
Is there a second?
I'm sorry, could you reread the number?
V-10961-14-UP-2. Wrong item?
No? Is there a second?
That's right. I'll second.
Thank you. All those in favor?
Aye.
Aye.
Next case, please.
This is V-11058-15-UP-2. This is a use permit amendment request by John and Dorte Hardage to permit a setback of 20 feet to a new garage from the 24th Road North right-of-way instead of 25 feet is required, 4.3 feet between the new garage and the existing home, and 0 feet between the new garage and a new stairway instead of 8 feet is required. So the construction of a new detached garage and a stairway in the rear yard. It's in the R6 zoning district, premises known as 4647 24th Street North, and the motions to defer this to the July 13th hearing.
Madam Chairman,
Mr. Owen.
I move that the Board of Zoning Appeals defer the use permit V-11058-15-UP-2 to the July 13th, 2016 BZA hearing.
Second?
Moved and seconded. All those in favor?
Aye.
Aye.
Thank you. Next case, please.
This is V-11144-16-UP-1, and this is a use permit request by Franklin and Anita Cater. And this is to permit a setback of 5 feet to the eaves and 5.1 feet to the porch base from the right side property line instead of 8 feet is required, and an aggregate side yard of 16.6 feet instead of 18 feet is required. For the construction of a new front porch and an eave overhang for a second-story addition above the first floor walls. It's in the R6 zoning district, premises known as 611 North Edison Street.
Can we hear from the applicant, please? Hi.
So what we want to do is, well, first, we spoke to Mr. Knoxon earlier today by email about getting some signatures from neighbors. So I have those here.
Very good. Thank you. Any other comments or that you'd like us to hear?
Nothing really in addition to what's stated in the application. Our interest is simply in building upward from the existing, on the existing walls of the house. So this wouldn't increase the footprint of the house. It would just build a second-story dormer on the back.
Okay, thank you. There are no speakers.
Madam Chair,
Mr. Melnick.
I'd like to make a motion.
Please.
All right, so in case V-1114416-UP1, I move that the Board of Zoning Appeals adopt the attached resolution granting the subject use permit with the conditions as stated.
Thank you. Moved and seconded. All those in favor?
Aye.
Thanks very much.
Thanks for this.
Next case, please.
This case is V-11145-16-UP-1. This is a use permit request by Charles and Rachel Moore. is to permit a setback at 13.1 feet to the eave and 14.1 feet to the wall from the rear property line instead of 25 feet as required. It's for the construction of a new rear screen porch. It's in the R6 zoning district, premises known as 929 North Potomac Street.
Questions of staff?
I have a question.
Yes, Mr. Owen.
In the staff report, the staff analysis for item number 1 answers the question, would the proposal promote compatibility development with the surrounding neighborhood, et cetera, et cetera, et cetera. And then the staff analysis is that the proposal would not be compatible with the surrounding neighborhood because the placement would not be similar to the structures on property surrounding the subject property. And then you identified 2 similar encroachments within a 5-block radius of the subject property. So do I correctly understand that you are only measuring situations in which there was an encroachment, but you're not looking at by right built conditions that might be similar?
That's correct.
So even if, for example, the next door neighbor had a very similar condition back porch, if it was by right, you would not consider that as relevant to question number 1.
Exactly. It would be, 15 more feet or 10 more feet further from the setback or from the property line.
Thank you.
Other questions? We hear from the applicant, please.
Good evening. I'm Robert Parker. I'm the contractor for the Moores. They came to me asking for some insect-protected screened-in area in the back of their home. I explained to them, after looking at their plat, that they were previous owners had built up to the buildable line, and as you saw in some of the prior photographs, prior owners also constructed a red gazebo in the backyard, which currently isn't screened in, but is allowable as a secondary structure. They asked me if they could construct something that was attached to the house that would provide insect protection, and in that process take down the gazebo, the red gazebo you see here. And I explained that the only way to do that was to get a approval from the board here. So that's what they're asking for.
Okay. Questions of the applicant's representative? No? Discussion?
Is it just the gazebo that you're removing or also the brick area next to it?
They have some additional landscaping that they'll do, which is, those are concrete pavers that I think will be pulled up, but the gazebo will be taken down.
So would there be a net reduction in coverage?
I believe there will be, because right now that's all concrete pavers in the foreground of the picture.
Okay, thank you.
Other questions?
On the question of coverage, there's no coverage issue here.
No, patios at grade do not count towards coverage.
Madam Chair, I have no problem supporting this request. So I'm happy to move the alternative resolution. I move that the Board of Zoning Appeals adopt the alternative resolution permitting in use permit V11145-16-UP-1 permitting the porch.
I'll second.
Madam Chairman.
Mr. Owen.
I'm also in support of the motion. I am persuaded in part by the applicant's assertion that the lot size and shape and the siting of this house as compared to other houses in the neighborhood makes it a little bit unusual. And so I don't think that it's comparable. I don't think that staff and the next door neighbor appears to have a similar back porch that appears to be by right. And I think the characteristics of the site suggest that usually, perhaps for this particular parcel, it would be in keeping with the neighborhood to afford this accommodation. I also note that there's a pretty serious grade change behind this parcel, and so the detriment to the privacy of neighbors to the rear is unusually low. So for those reasons, I think variances are often tied to unusual conditions of the lot, and I think that this lot has unusual conditions, and so I'll support the motion.
Thank you. It's been moved and seconded. All those in favor?
Aye.
Aye.
Thank you.
Next case.
Next case is V-11146-16-UP-1, use permit request by Nina Pelleter and William Voltaggio to permit a setback of 3.3 feet to the eaves of the porch and second-story addition and 5.1 feet to the porch floor from the right side property line instead of 8 feet as required. Also, an aggregate side yard of 13.5 feet instead of 18 feet is required. So the construction of a new front porch and a new second-story addition above the first floor walls. It's in the R6 zoning district, premises known as 1214 North Abingdon Street.
Questions of staff? We hear from the applicant, please.
Hello, members of the panel. Thank you so much for, or members of the board for hearing me out. I'm Nina Pelletier. I've lived in Arlington for about 16 years now. My husband's not here with me tonight, but he's lived in Arlington for about almost 30 years. We bought our house in 2002. It's a great, typical Cape Cod house. We hope to age in place in our house, and what we're trying to do, and we've got the services of a wonderful architect, is to use the space better. And along with that, to have a little bit of a front porch on the front of the house. It follows the line of the existing wall, so it's not encroaching overly onto our neighbor's driveway or anything like that. So the plan also calls for some lovely eaves on both sides of the house, and that's in keeping with the rest of the architecture in our neighborhood. We've gotten letters of support from our neighbors on both sides as well, and I've heard no opposition. So I hope that the board can see its way clear to approving our request for a use permit for our porch and eaves. Thank you.
Questions for the applicant?
This photograph that we have,
It's a terrible photograph.
a work in progress?
Yes, so the contractor started, they're not doing the porch part yet. We have a permit that has alternate plans, so they haven't done that yet. But so it's really not a good representation. The house is much cuter than that, or was, and will be. Right? It's a rambler instead of a cape. I don't know. So.
Thank you. I have a speaker slip. Robert Gwynn.
He's our architect.
Did you have something you wanted to say?
I just wanted to come before you and offer my services to answer any questions or comments that you might have. My name is Robert Gwynn. I work for Moore Architects.
Any questions for the architect?
No,
Thank you. Okay, what's your
I'd like-
pleasure?
I'd like to make a motion, please.
Please.
All right. So in case V1114616 UP1, I move that the Board of Zoning Appeals adopt the attached resolution granting the subject use permit with the conditions as set forth in the resolution.
Is there? Thank you. Moved and seconded. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Next case is V-11147-16-UP-1. This is a use permit request by Andrew and Julie Feltman. This is to permit a setback of 16.6 feet to the eave and 17.4 feet to the stoop base from the North Jefferson Street right-of-way instead of 21 feet as required, and 6.3 feet to the eave and 6.8 feet to the stoop base from the right side property line instead of 10 feet as required. And finally, an aggregate side yard of 12.8 feet instead of 18 feet as required. So the construction of a new covered front stoop and a covered right side stoop. This is in the R6 zoning district, premises known as 806 North Jefferson Street.
Questions of staff? We hear from the applicant, please.
Thank you, Madam Chair and members of the board. I'm Andrew Feltman, along with my wife Julie. We're the homeowners. And we thank you for hearing our case, and we thank staff for their work on it. We especially appreciate their recommendation to approve it, and we hope you follow that recommendation. We would like you to approve it. The project, as you see, as described, is to build porches over our existing stoops on the front and the side. Those stoops are in the setback areas, so that's why we're here. But two essential elements, and they are in the report that staff prepared. These will be open porches. They won't be enclosed. Also, there will be no increase in the footprint at grade. We're going to build columns in the roof structure over the existing stoops, which, as you've seen in the photographs, they are currently above grade. That's it. Thank you very much for your time.
Thank you. Questions for?
Did you share this proposal with your neighbors?
We've talked to several neighbors, and they all like it. They all like the fact that we're a family moving in. The house had been a very transient rental property for a long time. That's obviously not your business, but it's people have said, you need a variance for this? Okay, well, but they're very supportive.
Any questions? Comments? Motion?
Madam Chair?
Mr. Malnick,
Please.
please.
Okay. In case D1114716 UP1, I'd like to make a motion that the Board of Zoning Appeals adopt the attached resolution granting the subject use permit with conditions as stated.
Second.
Moved and seconded. All those in favor?
Aye.
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 Thank you, ma'am. Thank you, Board.
Next case, please.
This is V-11148-16-UP-1. This is a use permit request by John and Julia Hrabovkat to permit a setback of 16 feet to the covered front stoop, 18.5 feet to the eave, and 20 feet to the two-story addition from the North Dinwiddie Street right-of-way instead of 25 feet as required. Also, an aggregate side yard of 16 feet instead of 18 feet is required, and also a setback of 0.2 feet to the eave and 0.9 feet to an existing shed from the left side property line instead of 1 foot as required. So the construction of a new 3-story front addition, a new front covered stoop, and to maintain an existing detached shed in the left side yard. It's in the R27 zoning district on a premises known as 2117 North Dinwiddie Street.
Any questions for staff? We hear from the applicant, please.
Good evening. My name is Julie Hrabovchak. Seeking a use permit for an addition. When we bought our house, it was my husband, myself, and 2 cats. We've now added a dog and 2 kids to the mix. So the house that we thought was more than large enough when we purchased, it's not quite what we thought it would be. Our permit was for the multi-story addition to the front of the house. We were not aware that there was a problem with the shed until it was brought up by Mr. Noxon. We have since spoken to the homeowner whose property is affected by our shed. He has an approval of the addition and the existing shed as it is. We have spoken with his renter as well, also did not have a problem with the shed. The shed needs a new roof. So one thing that we have, since we submitted our application, have discussed is putting a new roof with a gutter system onto the shed to redirect water onto our property so it would not affect our neighbors.
Questions of the applicant?
Yes.
Ms. Malice?
I looked at the signatures that you had collected, and they're not nearby. The ones in our staff report are not nearby neighbors.
2106 is diagonal to the addition. 142 is diagonal to us on the other side. We cannot catch the homeowner that is directly across the street from us. They also have a small child, so our hours are just not matching up with theirs. We now have, as I said, my husband spoke to the neighbor behind us to the side where the shed is. I do have his signature as well, and it's supplement to what we've already submitted, yes.
Can you share that with us?
If I could get a copy back.
We have to keep this, but I can give you a copy back tomorrow.
Okay, any other questions for the applicant? Sorry? Oh, okay.
But you do not have a signature from 2118 North Cameron Street, is that right?
Behind?
Immediate rear neighbor? I don't see that on this.
2118, directly behind our property, is a church.
Over which property does the shed abut? Oh, I see there. Got it.
The large structure to the rear is a church.
So it's 2906 and 2910 and 2908, 22nd Street that it overhangs.
It's 4906 and 08.
49, right.
Also, the federal style, it's one building, two separate addresses at the property.
So on the photo here, the shed overhangs, so there's three properties there on 22nd Street, the White House and then two that look kind of gray, and then the church. So you appear to have a signature from 06 and 08, which is the third one over from the left, is that right?
Yes, where the shed actually backs to that property line.
Okay, and not from the middle one, but the middle one does not actually abut the shed, is that right?
Correct. We have attempted to contact her several times and have had not any luck at all.
And that building immediately to your rear is part of the church complex where the bus is in between? Is that right?
Is the church, yes.
It's the church. All right. And have you talked to them?
We have not.
Okay. Thank you.
Any other questions?
Can the shed be moved?
It is a poured concrete foundation. To become in compliance, we can take a foot off the back of it if we need to do that. There is no back to the shed currently. There's a gap between where the shed ends and the fence.
There's no back to the shed?
No, ma'am. It's only three-sided.
I see. It's up against the fence.
So we can attempt to take a foot off of the back of it. It's just storage. It's just very tight storage at this point.
So now I have a question.
Mr. Owen?
Would they be non-compliant if they left the slab but moved the rest of the shed? Do they need this use permit in order to keep the slab where it is alone?
At this point, it wouldn't even be considered a structure to us if it's less than 8 inches off the ground.
Okay. So the slab
be like a patio.
So the slab no one needs to remove the slab to become compliant?
Yeah.
Just the walls? Okay. I'm ready to make a motion.
Thank you.
I'm going to move the staff recommendation, which is approval of the addition in the stoop and denial of the shed, which I understand is by right if they move it a foot back. Is that right?
Correct.
Okay, yes. So that's the motion.
I'll second.
Do I need to read it? Is there?
Yes.
I don't see the I move part, and it's a page long.
Just,
I move the motion appearing on page 5 of the staff report for approval and addition of the stoop and denial of the shed.
with the case number?
Oh, and the case number being V-11148-16-UP-1.
Thank you.
Second.
Second, okay. All those in favor?
Aye.
Aye.
Aye. Next case, please.
Next case is V-11149-16-UP-1. This is a use permit request by Sawyer Blasek and Esther Kim to permit a setback of 12 feet to the egress window wells, 13.8 feet to the eave, and 15.2 feet to the wall of the new two-story addition and rear deck from the 21st Street North right-of-way instead of 25 feet as required, 6.7 feet to the two-story addition from the left side property line instead of 8 feet as required, It's all for the construction of a new 2-story rear addition and a rear deck, and 2 new right-size egress window wells. This is in the R6 zoning district, premises known as 2101 North Emerson Street. You'll actually see in the report that the window wells have been withdrawn since a basement is no longer proposed. So that's been struck out of the resolution.
Thank you. Questions for staff? We hear from the applicant, please.
Apologize at the start. I'm a very nervous public speaker. But Madam Chairman, members of the board, I appreciate you considering our application. A little bit about us. We're in the process of closing on this house right now, and as approved by the current owner of the house, we being the purchasers, we're submitting this application for an addition of the current size of the house in order to increase the size of it to meet the living needs of our family and the expected increased size of our family, so that it's more livable for us. A little bit about us, and my wife is here as well, and she also thanks you for considering our application. Our 10-month-old is unfortunately not able to make it. We are planning on one more child in the near future. We have an in-law who I'm very fortunate, not because she's here, to very much love and adore, and we will be expecting her to be moving in with us in the near future. So a 2-bedroom, 2-bathroom house, 866 square feet does not meet our living needs now or in the future. And so we're asking to increase the size of it to a 3-bedroom, 3-bathroom house, which would ultimately be approximately 1,700 square feet. The main reason we're submitting this application is because the lot is unusual. It's a 5,000 square foot lot. It's a 40-foot wide lot, and it sits on a corner, so there are 2 25-foot setbacks to the front and to the side. We're not asking for an increase closer to the property lines. We're actually asking for an addition moving to the rear, so it's adjacent to what the property lines currently are as it was built in 1931, just expanding along those lines. So the other reason why we are would be helpful to have an increased house size is a little bit of research in the neighborhood as we're preparing to move in. We were unfortunately unable to acquire a daycare for our child, and we'll need increased space in order to have a nanny share with some friends that already live in the neighborhood and to allow them to take care of our child as we both work full-time. We have conducted outreach. We received signatures from our immediate neighbors to the west, to the east. After the application was submitted, we managed to meet with the neighbors to the south and receive their approval as well as their son's approval. The lot north to us is actually vacant right now. There's just a foundation, so we were unable to receive a signature as there's no living person there right now. But outside of that, it is compatible with what we had found to be additional adjustments to construction in the neighborhood. We had found 6. The staff, their much better research, had found 8 approved adjustments to the construction in the nearby neighborhood. And we also found through the survey that our lot is actually further away from the 21st Street setback than the other lots that had construction previously. So our compatibility is actually increased compared to what they had conducted as their construction. We had also received a Civics Association signature of approval and made a few friends in doing so. And I do not want to spend too much more of this time. This has been a very long night for all of you, and I appreciate your consideration for that and happy to answer additional questions.
Thank you. Any questions for the applicant?
Yeah, your next-door neighbor.
Yes.
You said that you do not have approval from them?
Oh, no, to the north, there's no one living there, so we were unable to receive approval.
There's no owner of record?
There's no house. It's just a foundation. It's a
Oh.
dilapidated lot.
That was one of our previous cases, I think, last year.
But there's an owner of the lot.
I believe it's actually in transfer right now. They had sold it recently, and we've been trying through our real estate agent to get to reach out to them, but they've not been able to contact this new person. And we're not sure if they've actually fully closed on the house yet.
Any other questions? Thank you.
Thank you.
What's your pleasure?
I'll move to grant the permit. I'll move, I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-11149-16-UP-1, subject to the conditions listed in the resolution.
Thank you. Second?
Second.
Thank you. Moved and seconded. All those in favor?
Aye.
Aye.
Next case, please.
Next case is V-11150-16-UP-1. This is a use permit request by Karen Sutter and Charles Zenzi. This is to permit a setback of 2.7 feet to the eave and 3 feet to the wall from the right side property line instead of 8 feet as required, and 5.8 feet to the eave and 6 feet to the wall from the left side property line instead of 10 feet as required. Then also an aggregate side yard of 8.5 feet instead of 18 feet as required. It's for the construction of a new second-story additions above the right and left side enclosed porches. It's in the R6 zoning district on the premises known as 5975 9th Street North.
Questions for staff? Hearing none, we hear from the applicant, please.
Hi, good evening. I'm Karen Sutter. I'm here with my husband, Charlie Zenzi. We've lived at 5975 North 9th Street for 14 years. We're here before you this evening because we're doing a home renovation project. And as part of that project, we're requesting to be able to build over the long-standing side additions to the left of the house and to the right of the house. As indicated in the staff report, the left side addition has a 6-foot setback. In the very back right corner of the right side addition has a 3-foot setback. We thank the staff for its careful review of our proposal. We appreciate their recommendation to approve being able to build up over the left side addition. And what we're asking for is to consider their alternative proposal tonight to also be able to build up over the right side addition. We understand the concerns that were expressed about the right side addition, so what we wanted to do is just take this time to introduce a couple other things for your consideration. The first thing is that the area on the right side addition, the area that's we're requesting the 3-foot setback for, involves, we estimate it's about 4 square feet. It's a small triangle on the back right corner of the right addition. And I would draw your attention in the staff report in the PDF, it's page 6, so it's after the written component. You can see the picture of the structure of the lot. And what you'll see is our group of houses in this section in Dominion Hills is shaped a little bit like a pie in the way that we're wedged in there. And with the angle of the house, what you'll notice, you can see the back on the right addition there, the back corner, it's that little 4 square foot area is the 3-foot setback, but you almost immediately go to 4, then to 5, and by the time you come to that front right corner, you're 8.7. So it's not the whole side of the wall, it's just that tiny back corner. The other thing I wanted to note, one of the things that we had noticed in the report that the staff had carefully prepared is that they did identify a precedent of a 3-foot setback on a property in the neighborhood that's a block from us. And then we also noticed several previous projects nearby had also received approval for 5-foot setbacks, which is most of that wall, 5 and then becoming all the way to the 8.7. And then I just wanted to emphasize 2 other things. In designing our project, one of our key goals has been to better integrate the house with the yard. So as part of the project that's not before you, but part of the project for the renovation, we're adding an open front porch and an open back porch. The other goal that we're trying to do, and you can see in the aerial snapshot, when we bought the house, that back addition is quite large. And so what we're trying to do is use the existing footprints of the side additions and bring that back addition 8 feet towards the main house, taking off 8 feet from the back, which would shorten the wall, and on the right side of the back addition, also bringing that in by several feet, so to reduce the footprint there. We also wanted to mention that we've met individually with affected neighbors. We submitted in the proposal signatures of the people that we met with. There are 2 people that are not on there. To the right side is a renter that we know them quite well. They have small children that are friends with our children. We didn't feel comfortable asking them to sign. We didn't know the owner. They've been overseas for a long time. We've been emailing back and forth. They are supportive of the project. I sent Mr. Noxon's information. I don't know if they sent anything in. Their son just graduated from high school on Friday. So if there's anything you need on follow-up, I'm happy to do that. But they have told us by email that they are supportive of what we're doing. So again, in closing, we just want to say we really appreciate your consideration. We appreciate the careful review of Mr. Noxon and his staff. And we're be pleased to answer any questions or provide any additional information you might need. Thank you very much.
Thank you. Questions for the applicant? No, thank you.
I'm prepared to make a motion.
Thank you. Please.
If I could. All right. So in case the 1115016 UP1, what I would propose is that the BZA adopt the alternative resolution as approval as advertised with the conditions as stated.
Sorry. Is there a second?
I'll second.
Thank you. Discussion? All those in favor? Aye.
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 I would have supported the staff recommendation, so no.
3-1. Thank you. Next case, please.
Next case is V-11151-16-VA-1. This is a variance request by Thomas and Vicky Moffitt. This is to permit a total lot coverage of 60.1% instead of 45% as permitted. It's for the construction of a new rear deck. It's in the R6 zoning district on the premises known as 5975 9th Street North. Or sorry, I got that wrong. 6030 22nd Street North.
Questions for staff? Hear from the applicant, please.
Good evening. Thank you for hearing our application. I'm Tom Moffitt, owner of the property, along with my wife, Vicki, who couldn't be here tonight. This is an expansion of an existing deck, about 100 square feet. That's what we're looking for. And I would argue our properties are somewhat unique. As the staff report says, our property and our two neighbors to the west were all built at the same time, 1996, and they're the exact same footprint. And it's kind of unique. They're 50-foot lots, 50-foot wide, so narrower than an R6 should be. Slightly smaller than the total square feet, but not much. But they have a two-car garage in the back on the opposite side from where the driveway enters. So it's all driveway, going all the way down the length of the lot, turning to the garage. So in 1996, I guess it maxed out the lot coverage. Then in 2006, when lot coverage changed, we're now, it's going to sound kind of counterintuitive, but we're way over. And that's kind of what makes us unique. In 1996, we could have traded, we want another 100 square feet of deck. We could have taken off a little bit of, driveway or something, but where we are now, we're in a straitjacket. So that's what I think is unique about the property.
Questions for Mr. Moffitt?
What is the problem with reducing the size of your deck to be conforming?
Reducing?
Existing? Is right now you are going over what you have.
Right.
Is there a problem with reducing the size of your deck to be at least equal with what you have today?
Well, one thing we're going to do is move the stairs to one side. I guess we could do that and stay equal, but I think we're not allowed to make any changes. Is that right, without a variance? I don't think I could put in a bluebird house, on a little 6x6 pole with a house at the top. I don't.
So they're existing non-conforming? Is that what?
That's correct.
And so to make any substantial change, they need a variance?
That is correct.
Okay.
So again, what would be the reason that you couldn't at least be equal to what you have today?
Well, we could just keep the deck we have and be equal with what we have today.
In terms of building
Oh, you mean, could I like take off some of the, oh, I probably could, but I'd need a variance to do that.
I understand that you need a variance in any case, but would you be able to build this deck to equal the coverage that you have now?
I think I could, yeah, I could take off enough driveway.
Okay.
Other questions?
I'm not inclined to expand the coverage, but I do concede that, you know, you have a situation where your existing is over coverage. So I would, my view would be to allow a deck equal to the coverage that you have today.
Any other comments?
I would just make the comment that, you know, in examining the purposes of the coverage limitations in the ordinance, it seems to me that the three purposes that we mentioned, I mentioned earlier in the evening, here, one is the visual appearance of bulk and so forth from the neighbor's perspective, and the second one is stormwater. So I think that this particular request does not seem to very heavily impact the neighbor appearance bulk thing, because there's an outbuilding behind that screens it. And so I'm less troubled from that purpose of the coverage limitations. I think that that's a reason to be supportive of whatever gets built here. But I don't see an offer to mitigate stormwater runoff, which is another reason why the ordinance has been tightened up. And so I would only be inclined to support a variance here if there was a condition about stormwater. So that's what I'm offering, and I don't know if there's something that could be forthcoming on that count.
Could I address that?
By all means.
Go ahead.
I don't know all the details about it, but I heard rain barrels mentioned here earlier. We'd be more than happy to put in rain barrels if that would help.
Yeah, my problem is I'm not an engineer,
Yeah,
so I don't know what to propose. But I would want it to be, I would want some assurance that it was meeting the county's purposes and reducing runoff. And it seems like you might be willing to do something. So I think I might, go ahead.
Mr. Melnick?
Okay, yeah, and I don't recall offhand, I don't think this was addressed, but underneath the deck, is it just going to be soil?
Soil, yes.
Okay, so in effect, you're not stopping the soil from for water from being able to enter the soil,
No.
Like a building or asphalt or something. Okay, just, I wanted that clarification about stormwater.
That's a good point.
Mr. Owen?
I think my inclination would be to, if the applicant is willing, to defer this and allow the applicant to submit something that is clearer about stormwater runoff. But I'm super close to approval, so depending on what else is offered, I might vote for that too.
I will move a deferral to provide the applicant some time to consider stormwater measures and to consider a deck equivalent to what you have today.
You mean a total lot coverage?
Lot coverage, yes.
Second.
Did you give out the case number and the date, please?
Sorry. Case number V11151-16-VA-1, I would move that we defer to the July meeting. Is that
It's July 13th, right?
July meeting for the reasons I mentioned earlier?
Second.
All those, okay. All those in favor?
Aye.
Aye.
Thank you.
See you in July.
I bet you'll make it.
I've just got to figure out how to do the rainwater thing.
I bet it'll work.
Next case, please.
All right, this is V-11152-16-UP-1. This is a use permit request by Sean Sargent to permit a setback of 13.8 feet to the eave and 15.2 feet to the wall of a new two-story front addition and 15.5 feet to the front porch from the 19th Street North right-of-way instead of 25 feet as required. Also 7.9 feet to the two-story front addition and right side property line instead of 8 feet as required, and an aggregate side yard of 17.4 feet instead of 18 feet as required. This is all for the construction of a new two-story front addition and a new front porch. It's in the R6 zoning district on a premises known as 6712 19th Street North.
Thank you. Questions for staff? Hear from the applicant, please.
Yes, thank you. Yeah, the front part of this house was built in 1900, and there's significant issues with its age, being structural issues, water damage, that sort of thing. So we actually want to pull all that down and make something else further back away from the street. Currently, you can see from the picture, we're about 3 feet from the street, but we're proposing would be around 15 or so. So we're moving quite back, and also back from our neighbor's property line. We've talked with our neighbors. They all seem very supportive of what we're trying to do here. Part of the plan is also a one-car garage, so we will be pulling a car off the street for street parking, so both cars should be in there. And it should look visibly similar to the other houses around our block because they are all at a similar setback, not at the 25-foot. So we should be pretty much in line with what the other houses in the block already have.
Questions for the applicant? I think it'll be a big improvement. Motion?
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V-11152-16-UP-1, subject to the conditions listed in the resolution.
Second.
Moved and seconded. All those in favor?
Aye.
Aye.
Thank you. Next case, please.
Next case is V-11153-16-UP-1. This is a use permit request by Joseph King, and this is to permit a setback of 4.3 feet to the eave and 4.9 feet to the wall from the left side property line instead of 8 feet is required. It's for the construction of a new two-story rear addition. It's in the R5 zoning district on a premises known as 3212 12th Street South.
Thank you. And just as we're talking about inches here.
Correct.
Thank you. Any other questions for staff? Applicant, please.
Good evening. I'm Joe King. My wife and I are proposing a two-story addition off the back of our home. The house was constructed originally in 1939, and the existing left side boundary is 4.9 feet to the wall of the house. We are proposing that the addition is constructed maintains that line. I see that staff has supported a 5-foot setback, which we can live with. However, that 1.2 inches is kind of killing me a little bit, and I'm hoping that the board will consider, for aesthetic purposes and also connecting the old structure with the new structure will be a lot easier if it's a straight textual line.
Madam Chair.
Yes, sir.
If you could, just go into some detail about, just we're talking inches here, but how would you be affected by having to comply with the staff's recommendation?
Well, aesthetically, I would have to put up some sort of trim between the 1.2 inch offset, and also the connection. When you're connecting two walls this way as opposed to a slight offset, it would allow me to put bracing, plywood bracing between the two, the old house and the new addition, to make a nice rigid connection, and also the foundation connections, putting rebar into the existing foundation to connect the new one. If it's offset slightly, it's going to be made more difficult.
Okay, thank you.
Any other questions for applicant or staff?
Madam Chair?
Mr. Mullen,
More speakers. I'd like to make a motion.
please.
All right. So in case V1115316 UP1, I move that the Board of Zoning Appeals adopt the attached, alternative resolution. Approval is advertised with the conditions as stated.
Is there a second?
Second.
Moved and seconded. All those in favor of the alternative resolution?
Aye.
Thank you.
That's your inch.
Thank you. Next case, please.
The next case is, this is another deferral request. This is V-11154-16-UP-1. This is a use permit request by Terry and Elaine Eby. This is to permit a setback of 2.9 feet to the eave and 3.4 feet to the wall of a new one-story addition, a landing, and a stairway from the right side property line instead of 8 feet is required. Also, an aggregate side yard of 14.8 feet instead of 18 feet is required. It's all for the construction of a new one-story right side addition with a landing and stairs. This is in a R6 zoning district, premises known as 3817 13th Street South.
Madam Chairman,
Mr. Owen,
I move that in case V-11154-16-UP-1, that the Board of Zoning Appeals defer the matter to the July 13th, 2016 meeting.
Second.
moved and seconded. All those in favor?
Aye.
Aye. July is going to be busy.
All right, brings us to our last case tonight. This is V-11155-16-UP-1. This is a use permit request by Jeffrey and Melissa Bishop, and this is to permit a setback of 0 feet to the eave, 0.3 feet to the second story wall and siding, 3 feet to the eave, and 4.3 feet to the one-story left side addition, 7.2 feet to the eave, and 8.9 feet to the right side porch base, 8 feet to the eave and 9.1 feet to the second story cantilevered right side addition, and 16.3 feet to the left side areaway. And this is all from the North Nelson Street right of way instead of 25 feet is required. And then also 17.7 feet to the areaway, 16.2 feet to the porch eave, 16.2 feet to the eave, and 17.1 feet to the cantilevered second story addition, 4.6 feet to the eave, and 5.5 feet to the second story addition wall and siding from the rear property line instead of 25 feet is required. It's all for the construction of a new eave overhang for a second-story addition above the first floor walls, new cantilevered second-story right side addition, new right side porch, a new left side one-story addition, and a new left side basement areaway. This is in the R6 zoning district on a premises known as 3700 17th Street North.
Questions for the staff? Hear from the applicant, please.
Good evening, and thank you very much for your time. My name is Arthur Neal, Neal Construction Group. I represent Joffrey and Melissa Bishop, who are sitting here. This has been a fun thing to put together because every single millimeter in this property is non-conforming, and I want to thank Mr. Noxon for bearing with me and coaching me and just helping me put it all together. Basically, I think if you understand the concept, we want to put on a second story. And in the front, actually, let's call it on the right side, which is the 17th Street side, over the porch, over the screen porch, we're going to have a little 2-foot by about 14 or 15-foot bump out, part of the second level. And I needed to just clarify 2 words, and those words are found on page 7, and they are built over. In number 3, the applicants agree that the new additions shall not be expanded or further built over. Does that mean further built exceeding the architectural drawings I've already given you?
Correct. You can't build I would say, a third story above that second story addition.
Okay. we will definitely not do that. And this following, the second part of number 3 is, and that the new right side porch shall not be built over or enclosed. It will remain as a screened-in porch, the way it is now, and built over then, as I understand, meaning building over a second story on top of the porch?
Any other portion where you're not building the cantilevered portion above it.
Okay, that takes care of the semantics. I appreciate that. Do you have any questions?
Any questions for the applicant's agent?
Just impressed. I think the whole family is in attendance.
Oh, yes.
I hope we didn't keep you up too late.
Not always this long.
If you all recommend it, you know, according to the recommendation here, it's been well worth it.
Be worth it, yes.
It's been a challenge, but thank you very much.
You have a tough site.
Any questions?
Yeah, I'm sort of curious about the Nelson Street. I didn't get a chance to visit the site, but Nelson Street adjacent to the property, it looks like it terminates in a bike trail, basically?
It does,
Yeah.
it does.
It's like an
The
alley.
17th Street terminates just down, right there, and then it terminates here. And in all its wisdom, somewhere along the way, 17th Street used to be the front. And by changing the front now to North Nelson, which is on the functional left side, that creates a 25-foot setback in the front, 25-foot setback in the rear, which is 50 feet, and we got a 42-foot lot.
Do like county vehicles or any other kind of vehicles travel down?
There's no, you know, maybe, I mean, the most traffic there is people walking their dogs. No, I mean, and occasionally a county vehicle may come down to empty the small garbage thing that's at the end. Otherwise...
Right. It just seems to me that that's probably repaving that and maintaining it as a county street for that distance is
That makes no
a
sense.
poor use of public resources, and maybe someone should pursue, what's it called? There's a funny word they use when we...
Vacation.
A vacation, we vacate the street. But look into that. You might be able to benefit from a vacation of part of North Nelson Street.
It's true.
To get them to repave it, you say?
To reduce it to a bike trail.
It's not an issue.
What would that do to our...
It's not an issue for
I'm going to take what we
tonight.
can get,
This is,
okay?
no. I'm sorry. I didn't mean to worry you. I'm going to vote for everything you asked for.
Thank you,
I'm
sir.
saying after you leave here and you want another hobby, consider asking the county to tear up part of that street and make your home more beautiful.
And you can come back here.
Very interesting, because nobody uses it.
Right. Okay.
All right, thank you so much.
Okay. Do I hear a motion?
Madam Chair,
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V11155-16-UP-1, subject to the conditions listed in the resolution.
Is there a second?
Second.
All those in favor?
Aye.
Aye.
Your government at work. Thank you. We have minutes.
Difficult ones I've ever seen, that lot.
Minutes?
Minutes.
May 11th minutes.
Back of some sort.
I have
Edits?
question,
Changes?
edit,
Credits?
last page.
This page.
After the case, it says suggested resolution?
Oh, yeah.
Opposed to, is there an adopted resolution?
Well, the other ones just say
It's
resolution.
resolution. On the previous page, it just says resolution.
So is this the resolution?
Can that be removed?
Oh, that's because in the appeal language, it talks about a suggested resolution as opposed to just a resolution.
It's different language because it's an appeal?
The appeal tonight had the same language in it. I mean, we can remove that if you'd like, that's no problem.
At this point, it's not a suggested
As long as-
resolution,
yeah.
it's the
It is the
resolution.
adopted resolution, okay.
Okay. Any other comments? Motion?
Madam Chair, I move that the Board of Zoning Appeals adopt the minutes from the Wednesday, May 11th, 2016 meeting.
With the aforementioned change.
Aforementioned edit.
Change, second.
All those in favor? Aye.
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 I'll just make the observation, it's a good thing that we didn't wait for Mr. Smith, or we would still be talking about,
Email from him saying he wasn't going to come in just recently.
no worries, but not that we distinguished ourselves necessarily on that matter, but we might have done more if we had had 5.
I mean, I do feel a little chagrined that the odd number turned out to be highly relevant, but I do think it's different I do think the reason for moving things around the agenda matters, and to specifically move it around so that the applicant can get his favorite judge, I don't, I'm not cool with that.
Yeah, I think it was fine. I just found it a little unnerving to keep trying to get us through a round hole, and it never worked.
Personally, I think we ended up in a good place.
Yeah.
I think I saw them huddling immediately.
Yeah, good.
Have an adjournment?
I move to adjourn.
Second.
Aye.
Aye. Thank you. No, I didn't.